Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earned that subscription. For today's story, we are dealing with a Minnesota mom who decided to cut her 3-month-old son across the throat and then threw his body into a dumpster. She has been adjudicated to be competent for trial in the slashing her 3-month-old child's throat case. So we're going to learn a little bit more about this Minnesota Mother of the Year. Let's get started with this. Pictured here is Faradosia Omar Abdili, who did these things with the slashing and the disposal of the body in the dumpster in Minnesota. Okay, great. All right. A 28-year-old Minnesota mother who allegedly told authorities she slit the throat of a 3-month-old baby, then stuffed his body into a garbage bag and tossed it into a dumpster outside of her apartment building, has been found competent to stand trial for the horrific slaying by her doctor. Not that I necessarily need to point this out, but, please don't do those things. That's bad. In a letter to the Stearns County District Court Judge, Sarah Hennessy, a former psychologist deemed that Faraducio Abdilia had the requisite skills and abilities for trial competency according to court documents. The letter, which was written by Dr. Jody Beliski, says the determination on Abdili's mental state came after she was recently evaluated pursuant to rules of the Minnesota Rules of Criminal Procedure. Under the statute, the court holds a hearing, and if the court agrees with the determination, the criminal proceedings must resume. The judge has scheduled an omnibus hearing on the matter for February 13th. Okay, so what we're trying to look for is legal competency to stand trial, which is a pretty low list, right? Which isn't necessarily showing that she was competent at the time, right? So these are two different legal determinations. Was she insane then? Is she insane now? Right? So these are two possible things that one could evaluate, right? So as to whether or not she was insane then, that's something she would have to plead, obviously, and show that she was mentally infirm. But the question is whether or not she's sane now. Is she competent to stand trial? Competency to stand trial is pretty low bar. It's very low bar. Basically, you just have to understand the charges, and you have to understand in a sort of like what they are, and you have to understand the basics. Like, what is the role of a defense attorney? What is the role of a prosecutor? What is the role of a judge? What is the role of a jury? What are you being charged with? What does it mean? What are the possible implications, right? It's pretty simple. It's pretty simple, right? So unless you are so stark raving mad that you don't have any clue about anything in reality, about what reality is, right? You're competent to stand trial. This does not necessarily preclude you from pleading insanity, because the question was, well, whether you're insane at the time. Also, whether or not you're insane for the purposes of the crime and whether or not you're competent to stand trial are two different standards. They're similar, but they're not the same. So this whether or not she's sane or mentally infirm in some way that would help her in her criminal case yet to be determined. But she can understand the charges against her, so let's go forth to trial. A Stearns County grand jury in 2021 indicted Abdili on charges of first-degree premeditated murder and second-degree intentional murder. The penalty for premeditation is life. The penalty for second-degree murder is up to 40 years. As previously reported, officers with the St. Cloud Police Department arrested Abdili after a 911 caller tipped them off defendant's baby was dead. The male caller said a baby was missing, and the baby's mother had told him she had thrown the baby in the dumpster, according to a probable cause statement. So apparently, mother of the year over here confessed to somebody, told a neighbor, or told somebody about it. And the neighbor apparently called 911 and reported it. So good for the neighbor for calling it. And we have apparently a confession, right? Because the mother says, I killed my baby and put it in a dumpster, and then police come and find the baby in the dumpster, dead. So, yeah, the confession helps a lot with the trial. So, yeah, not looking great for her potential chances out there. The caller learned of the situation because of the defendant calling her mother, who lives out of state, who reported the stain. The mother appears to have tipped off others who went to the defendant's apartment to see what went wrong. So apparently mom over here received a call from daughter about killing her daughter, and grandmom decided to report on her child. So that would be a second confession. We have a confession to grandma. We have a confession to neighbor. Grandma decided to tell people. Neighbor decided to tell people. Responding witnesses were acquainted with the defendant and were told she claimed to have killed the child and put him into a dumpster behind the apartment. The man who called 911 and other witnesses went to look for the child but could not locate him. Witnesses were unsure at the time if the defendant was being truthful and called the police. So they decided to investigate for themselves, were unable to find the body, and called the police. It's like, maybe she's joking, maybe not, but maybe we should ask someone to look into this. The witnesses went to help and found the defendant crying and alone in her apartment. The defendant repeatedly stated she had killed her baby and thrown him away. So more people heard the confessions. We got mom, we got neighbor, we got other neighbors. Her trial is not going to go well for her. The baby boy was less than 4 months old. According to the probable cause statement, the defendant lived alone with the victim in the apartment. Here's how the police described their involvement. The authorities referred to the victim as Child A. Officers arrived on the scene and spoke to the defendant. Officers observed children's furniture in the residence, but no child present. Officers asked the defendant where Child A was. The defendant stated that Child A was in a dumpster behind the building. As officers were searching the dumpster, the defendant stated she stabbed Child A and put him into a black plastic garbage bag before putting him in the dumpster. At the same time, officers located the deceased body of Child A within the dumpster. The defendant was placed under arrest. Later, police read her Miranda rights and she agreed to talk. So the police questioned her at her apartment without reading her Miranda. Is this a problem? No, not necessarily, because for Miranda to apply, two things have to be true. Custodial interrogation, right? If the police are just asking you questions, but you're not in custody, Miranda doesn't apply. So when the police first come to your apartment and start asking you questions, they don't have to give Miranda because you're not in custody. Probably. We've seen some situations where that's not true, but those are fairly fact specific, right? We've seen some situations where you can get to custody with the police showing up to the apartment, but this doesn't seem like one of them. Also, even if somehow it was all the neighbors and the mom and the other neighbor. So first of all, no Miranda was required. Second of all, even if somehow it was, it doesn't really matter very much. So, define in custody. Well, I'll give you the short version of defining in custody. As a legal matter, to be in custody means that a reasonable person would not perceive themselves as free to leave. So that's basically the short test. Would a reasonable person feel like they could leave? So are the police doing something that shows that you cannot leave the apartment? So, are they closing the door and blocking your exit would be something? Or are they, if they put you under arrest, that obviously does it. But that's the sort of the linchpin, right? So the police merely asking you questions doesn't show that you don't have the ability to leave. So that's basically the short definition of in custody. The longer definition is where the law gets involved, but that covers it. The defendant stated that she was looking at Child A, wondering how she was going to get help. The defendant admitted she stabbed Child A with a knife from the kitchen. The defendant stated that Child A was crying prior to stabbing. The defendant demonstrated that she cut Child A across the throat. Apparently, she demonstrated it. Apparently, she did charades and demonstrated it. Super. The defendant stated she put Child A in a black bag with baby clothes and put the bag into a trash bin. Defendant stated she put the bag out the dumpster about 5 minutes after she stabbed the child. Defendant said she called her mom about 20 minutes later and told her mom what she had done. It's not going great. An autopsy has revealed the baby suffered a circumferential sharp force injury to the neck, which means slash across the throat, The manner of death was ruled homicide, I would think. After a few months of legal wrangling and mental health assessment, a judge ruled in February that not competent to stand trial. A subsequent document indicated the defendant had been committed by judicial order to an inpatient facility. So earlier, not competent, but she has been restored to competency. And apparently there's a bond somehow for this. $2 million without conditions and $1 million with conditions. So if anyone wants to pony up $2 million for bond, well, apparently that's an option somehow. Thus, that brings us to the end of the story of 28-year-old Pardusa Omar Abdili, who apparently sliced her 3-month-old child's neck with a knife, and then told mom, and then told a neighbor, and then told other neighbors, and then told the police. And then the body was located, and yeah. So, she was previously adjudicated not mentally competent to stand trial in February, but of course now it's 10 months later, and received psychiatric care, and so now apparently she's competent to stand trial. So, stand trial. So she can try to plead, obviously, some sort of mental deficiency at trial if you like, but of course that's pretty difficult. And even if she wins, she'd be committed. So I'm not sure how much of a win that really is, really, to be quite honest. But things are not looking really, really promising for her case, and at least for a moment. That brings us to the end of discussion of this tale.